Okay, everyone. This is Yusef. Was up late tonight, decided to make a video about this Minnesota Rule 220 that everyone is talking about. But there seems to be so much confusion surrounding. I had prepared an introductory speech, but I'm not going to waste your time with that, insulting people and everything. Just take a look around the internet after you watch this. I just want you to Google, put Minnesota Rule 220 into Google, put it on YouTube, and just look at all of the plethora of different videos and products and things that people are trying to sell you behind this Minnesota Rule 220. So without further ado, let's get to it. It's coming off my website. I'm going to make it bigger. I'll make sure that everybody can see it. Okay, that should be big enough. All right. Now, I wrote a article on my website, highfrequencyradionetwork.com, and I sent out an email, and I decided to do a video. I thought a video would be very good to do about this, and I titled the article, "Is the Minnesota Rule of Practice 220 saying what all the gurus say it is?" by Yusef. Now, let me read this to you. And the reason I'm reading it is because I've already put the links in and kind of like narrates my story a little bit of how I went about researching this Minnesota Rule 220. Because, there's some individuals out there saying I didn't know how to read and all this kind of stuff. And I mean, I was just amazed. First time I read Rule 220, I had a good sense of what it was talking about. But it wasn't until I was kind of compelled to do the research on this to demonstrate that not only did I know how to read, but that the individuals out there who are selling you all this stuff, they don't know how to read. And you need to really think about that, because there are individuals out there selling this information to you on a faulty premise. And you, all of you who are listening, you need to take more responsibility for yourselves and investigate this information thoroughly before you go about and start trying to utilize it and, jump on all these bandwagons and everything. But anyway, name of it again, okay, by Yusef. It says there's a movement that has escalated among the redemption circles of a process involving birth certificate authentication in order to become the registered owner of one's estate. This process is colloquially referred to as Minnesota Rule 220, which incorporated portions of the UCC and Article 4, Section 1 of the U.S. Constitution, which is the full faith and credit or comity clause. Now, I want to stop real quick and talk about this word Minnesota Rule 220. Okay, to me, this is the foundation of the problem. Is number one, they're not saying what the entire word is. It's Minnesota Rules of Practice 220. Okay, first and foremost, it's not Minnesota Rule 220. And there's a difference between a rule of practice and a rule of court, which I'm going to show you in just a second. These are rules of practice, okay? Now, it goes on, it says, well, I'm not opposed to authenticating the birth certificate for additional layers of security as it relates to travel purposes. And the reason I said that is because when you go to the federal website, that's what it's for. It's for traveling in different jurisdictions. That's why they want you to authenticate the birth certificate. So if you're in a foreign jurisdiction, you have something that the government itself has put their stamp of approval on in this foreign jurisdiction to demonstrate that you are who you say you are. Now it goes on, it says the sheer absurdity of locating an obscure rule of practice in a foreign jurisdiction and attempting to compel clerks in other states to recognize it was astounding to me. I took some time to research Minnesota Rules of Practice 220 regarding the birth certificate in order to determine if what the so-called gurus were saying was true or whether it was a misinterpretation that individuals took and ran with. First, look at what a rule of practice is. Using Bouvier's 1856 dictionary, we quickly come up with the definition. And I put a copy of Bouvier's on here as a link. you can click on it and it will take you over to the 1856 edition of Bouvier. And right here we can see, first of all, what a rule of court is. A rule of court, an order made by a court having competent jurisdiction. Rules of court are either general or special. The former are laws by which the practice of the court is governed. The latter are special orders made in particular cases. Disobedience to these is punished by giving judgment against the disobedient party or by attachment for contempt. And the word attachment means a warrant for an arrest. So when you get a court order and you refuse to follow a court order, they'll come and arrest you. Like in the case of child support. Child support, if you don't pay it, that is called a contempt of court. They're not arresting you because you didn't pay child support. They're arresting you because you didn't follow a court order. Same thing. If the woman takes the kids out of state and you want to go into the next state and you get an attorney over there, the first thing the attorney is going to say is, do you have a court order? Court orders are enforceable. These are court orders. All right, so let's look at the difference between a rule of court, and rules of practice. So here we got the rules of practice. Remember, it's called the Minnesota General Rules of Practice 220. Remember that? Catch that? Okay, now what is a rules of practice? Well, certain orders made by the courts for the purpose of regulating the practice of members of the bar and others. Every court of record has an inherent power to make rules for the transaction of its business, which rules they may from time to time change, alter, rescind, or repeal. While they are enforced, they must be applied to all cases which fall within them. They can use no discretion unless such discretion is authorized by the rules themselves. Rules of court cannot, of course, contravene the Constitution or the law of the land. And that goes to the judge, too, because these are Article I courts. These are statutes. These statutes are promulgated by the legislature, and the legislature will dictate what the officers of the court do, the attorneys, and everybody. They're the masters over all of this, or the legislature, okay? And that is why the judge is an administrator, because an administrator, when you look up the word ministerial duty in a Black's Law Dictionary, you can see that they don't have any discretion. They have to do what they're told. That's why that says that, okay? So now that we've gotten that out of the way, we got an understanding of the difference between a rule of practice and what a rule of court is. Now, while we're at it, we might as well define what a practice is. That also is in the Bouvier's 1856 edition, and I'm just gonna read it right here. Y'all can go and find it on your own. Now, what a practice is the form, manner, and order of conducting and carrying on suits or prosecution in the courts through their various stages, according to the principles of law and the rules laid down by the respective courts. By practice is also meant the business which an attorney or counselor does, as A and B has a good practice. The books on practice are very numerous, and he's going to name these, but there's no need to name them because, you know, this is the 1856 edition, and, you know, these are some very old books that he's talking about right here. But it goes on, it says, as we can see, there is a clear distinction between a rule of practice and a rule of court. Next, we take a look at Minnesota Rule 220 to find out exactly what its purpose is. We can locate that at the Minnesota website under General Rules of Practice. So when we click on that, oh, voila, and let me enhance this so you can see it. Okay, we see right here, these are the General Rules of Practice. General Rules of Practice for the district courts, adopted effective January 1st, 1992, with amendments effective through July 1st, 2016. Table of head notes, Title I, applicable rules of all court proceedings. And you'll see as we go down here, we'll see all of the rules, the general rules of court. Okay, these are rules, okay? They're not laws, they're rules of court. And down here, when we get to the third section, we're going to find something very interesting. We're going to see Title III, registration of land titles. Part A proceeding for initial registration, okay? So that's Part A, okay? So we have a Part B to this as well. proceedings subsequent to initial registration. All right, and then we have a Part C, which are miscellaneous provisions. And Part C, this is where we find 220 birth certificates, okay? Now, you can see that all of this, Part A, B, and C, fall under Title III, Registration of Land Titles. Now, if we want to get more specific with that, we can click on Rule 201, and it will tell us this. 201, General Rules of Practice. Rule 201, Applicability of the Rules. Rules 201 through 222, I think that Minnesota 220 would be within that purview. Of these rules apply to all actions and proceedings in the district court relating to registration of land titles, including proceedings subsequent to initial registration. Wow. So right here, we can read under the general rules of practice, Minnesota Rule 201, we can find out that Minnesota Rule 220 is dealing with land titles. Well, now that we found out that this is dealing with land titles, that should help us in our research. Okay, so what is it talking about then? When we go in there and we read Minnesota Rule 220, birth certificates. Let's look at it now. The Register of Titles is authorized to receive for registration of memorials upon any outstanding certificate of title. They skip over this word. Everybody I see, they skip over this word, outstanding certificate of title. It's called an outstanding certificate of title. You won't find the word outstanding certificate of title in a law dictionary because they're two separate words. But if you look at a Black's Law Dictionary under the word outstanding, it will reference a certificate of title. Okay, it get a 6th, 8th, or 9th edition, and you'll see that. Okay, so let's read it again. The Register of Titles is authorized to receive for registration of memorials upon any outstanding certificate of title an official birth certificate pertaining to a registered owner. Okay, so they can receive a certificate, a birth certificate pertaining to a registered owner. The registered owner that they're referring to is the owner that has the land. Okay, now I'm going to tell you, I'm going to preference all this and tell you what they're talking about. They're talking about minors who own land, okay, and their name is on title to property. So but you're going to see that. Let me start over. The Register of Titles is authorized to receive a registration of memorials up on, the word up on. Why are they receiving that? Up on an outstanding certificate of title. What are they receiving for it? An official birth certificate. What is the birth certificate pertaining to? The registered owner named in said certificate of title. So this birth certificate is being used as evidence to show that that person is the person named on the said certificate of title, showing their date of birth of said registered owner. The registered owner is the person, the registered owner of the land. I'm going to show you all of this in the statutes. Providing, okay, now providing. Now this is providing there is attached to said birth certificate an affidavit of an affiant who states that he or she is familiar with the facts recited. That's how all affidavits start off. Stating that the party named in said birth certificate is the same party as one of the owners named in said certificate of title. And then that thereafter the Register of Titles shall treat said registered owner as having attained the age of the majority at the date of 18 years after the date of birth shown by said certificate. What is this talking about? I'll tell you what it's talking about. It's talking about a minor who has property in his name, but he cannot, when you're under 18 years of age, you can't enter into a contract. So your property has to be held by a custodian. Okay, now once you reach the age of 18, that custodian has to provide an affidavit, and he comes in and proves that you are the person that is the same person on that particular deed, so the court can issue an order, and thereby you will start to be treated as reached the age of majority. Now, this is not me saying this. I'm going to show you that this is what this is talking about in all of this, okay? Now, from what we've learned so far, we can determine that the foregoing is speaking about a conveyance of land to a potential minor. So why all of the concern? Well, in the state of Minnesota, minors are allowed to hold property, but only under a custodian. This all falls under the Uniform Minors Transfer Act, which has been adopted by all states except for Michigan. In order for a minor to verify that he has reached the age of majority, which is 18, and legally capable of holding property, he will have to prove his age. The birth certificate is the only admissible evidence in court, and falls under the hearsay rule, which is codified under the Minnesota evidence rules at 803, 9, and 10. Birth certificate, when introduced into evidence, is hearsay and subject to objection by the opposing counsel, even if there is a declarant present. This requires the birth certificate to be authenticated. So let's look at some of this real quick and see where I got all this. Well, Yusef, where'd you get all, even though now when we read Rule 201 should have killed it. Should have killed it. But I already know that there are going to be individuals out there that because they got a business around this, they're going to go to great lengths. I don't know how they're going to do it, but it's going to happen, you know, some kind of way. They're going to get creative and find some kind of way to twist all this, even though, well, you know what? I shouldn't even have to worry about that because I know all of you listeners out there and the people watching this, you're intelligent. You know, you can see what I'm reading right now. So let me show you something else. Where did I get this from? Okay, let's look and see. Let's look and see. Okay. Okay. Now, make sure y'all can see this. Now, right here, you can see I went to the Social Security website, Program Operations Manual System, and this was in 2008. And it is a request for a formal legal opinion regarding the purchase of property by respective payees on behalf of minors. Okay, remember, minors can't enter into contracts. They can't enter into deeds because they can't be legally held liable for an obligation. They can't enter into contracts. Remember, you have to be in the age of majority to enter into a contract. So here's the opinion. Here's what it says. You asked us to determine whether minors are allowed to hold title to real or personal property in the 6 states in our region. And if so, whether there are any restrictions on the age of the minor or the types of property that a minor could hold. You also asked us to determine whether there are any specific requirements on how the property should be titled to reflect the minor as the title holder. We have concluded that in Illinois, Indiana, Michigan, and Wisconsin, minors can hold title to real or personal property, and that minors can be shown as the title holder of such property. In Ohio, a minor can hold title to real or personal property, but a minor can purchase. In Ohio, a minor can hold title to real or personal property, but a minor can purchase and own an automobile only if the minor's parent or guardian expressly authorizes that purchase. In Minnesota, a minor can hold title to real or personal property, but a state statute prohibits a minor from owning an automobile except in certain circumstances, not likely to occur in a situation involving back SSI payments to disabled child. None of the states in our region impose any particular restrictions concerning the age of minors. Now, but let's see, they're going to qualify this. Let's get down here to Minnesota. And what you're going to see in Minnesota, minors may own real property, okay? They may purchase personal property. Then you got the citations. Some court cases have suggested that a minor may purchase an automobile, all right? But under current law, Minnesota statute annotated, subsection 168.101, okay, a person under the age of 18 can own a passenger automobile or truck only if he or she meets one of the following conditions. And then they give you the 5 conditions where they can own a car. But here's where it gets interesting. Transfers under the Uniform Transfers Minor Act. And this is what you should read. All the states have adopted this act except for Michigan. Minnesota has a statute. I'll show you the statute. Minnesota has a statute of the Uniform Transfers to Minors Act. Just like the UCC, this is put together by the Uniform, the commissioners, the same people who wrote the Uniform Commercial Code are the same people who are writing all these uniform acts, because they're making a one world order. Remember that. They're attempting to unify all the laws. It goes on, it says, in our prior memorandum, we observe that minors can take title to property as provided in the Uniform Transfers to Minors Act and the Uniform Gifts to Minors Act. Except for Michigan, all states have adopted a version of the UTMA. Michigan has a version of the UGMA, okay, and it gives the statutes. Now, here's the key. All these statutes allow a minor to receive certain forms of property and have it held by a custodian for the use and benefit of the minor. See, that's the key. They can hold title to property, but it will be held by a custodian. Okay, now this is where you begin to understand what Minnesota Rule 220 is talking about. Okay, well, let's look at some of the laws as it relates to conveyances by custodians. All right, let's look at that next. And here we have it. Minnesota 527.405 conveyance by a custodian. Oh, and what do we have here? We have an affidavit of the custodian. Could this be what they're talking about? That the birth certificate has to be accompanied by an affidavit of a person who is familiar with the person in the certificate of title as well as in the birth certificate? That would make sense, wouldn't it? Well, in support of real property, isn't that what Rule 201 was telling us? And 220 and all that, Rule 201 through 222 is talking about conveyance of land. Okay, so in support of real property transaction, where an interest in real property is held in custodianship. Well, we just got through reading that if you're a minor and you got property in your name, the Uniform Minors Transfer Act dictates that it must be held by a custodian. And we know that Minnesota has adopted that act as well. And I'm going to show you that act in Minnesota. A custodian shall furnish to the grantee or other party to the transaction an affidavit attesting that, number one, the custodian has not resigned or been removed prior to executing the conveyance. And number two, the custodianship is not terminated, or if the custodianship has terminated, that the conveyance is to be to the minor or to the personal representative of the minor's estate. Okay, so we're talking about a conveyance to a minor once again. Look at all the facts are lining up. Number one, we know we're talking about a land conveyance. Rule 201 has told us that. Number two, we found out that the Uniform Transfer to Minors Act is effective in all states except for Michigan, and it dictates that they have to have a custodian. And number three, here's an affidavit. It says as an affidavit of effect of a person familiar with the facts. You're going to notice right here, form of affidavit. An affidavit under this section must be substantially in the following form. That doesn't mean it has to be exactly like this. It contains the different elements. Rule 220 says that this affidavit has to state that they are both familiar with those people. So they would have to include that in this affidavit. That's what they do in statutes. They tell you specifically what needs to be what in the particular document, what you need to say. So here's the affidavit of the custodian when we're talking about a conveyance of land to a minor. Okay? So let's look at next. Well, why does the birth certificate have to be authenticated? Well, let's look at that next. Now we're going to talk about the evidence rules, okay? Evidence, okay? What constitutes evidence? Okay, Rule 803, hearsay exceptions, okay? Availability of declarant immaterial. The following are not excluded by the hearsay rule, even though the declarant is available as a witness, okay? So they're not excluded. These are not excluded, okay? They're not excluded. They fall under the hearsay rule. And when you get down here to number 9, it talks about records of vital statistics. Records or data compilations in any form or births, fetal deaths, or marriages, if the report thereof was made to the public office pursuant to requirements of law. Okay, you see right here That right there, that falls under the hearsay rule. Now, they give you some explanations when you go on down 803-9 right here will tell you. Minnesota has adopted the Uniform Vital Statistics Act. Remember when I told you they're trying to make all of the rules uniform, and they always adopt them. That's why the Uniform Commercial Code, it was adopted as well. Pay attention, y'all, because they're trying to bring, there's going to be a one world order, one law, one religion, one person in control of everything. This is what they're moving toward. So Minnesota has adopted the Uniform Vital Statistics Act. Minnesota Statutes 1974, sections 144.151 to 144.204 and 144.49, which requires certain individuals to make reports to the State Board of Health concerning births, deaths, etc. Similarly, Minnesota Statutes 1974, section 51710 require the filing of marriage certificates. Minnesota Statute 1974, sections 144.167 and 600.20. However, so here it is, y'all, not all statements included in such certificates are admissible. So now we're questioning the admissibility of these particular documents coming from vital statistics. This is why they request that they be authenticated. And there has to be an affidavit accompanying it because you need two witnesses when you go into court. The authentication is a witness and the attestation of the custodian as well. Okay, so you need that. You always need two witnesses. Remember that. So right here now we understand why they are asking for the birth certificate to be authenticated. Now let's look at next and let's see what we got next. Okay. And I just read this. So, as we can see from the above, the Minnesota Rule 220 is a codification made for situations where a minor under the age of 18 may receive a conveyance of property from a custodian. This has nothing to do with the Uniform Commercial Code or any of the things that you're being told. As a matter of fact, Minnesota provides you with a copy of the certificate of title that they are referencing. You can find it at Minnesota Statutes 508.35, form of certificate. All right, so let's look at that next. Let's click on this. And what do we have here? Oh my goodness. It is the damn certificate title. I mean, 508.35. The certificate of title should contain the name and residence of the owner, a description of the land and of the estate of the owner therein, and shall by memorial, registration of memorials, contain a description of all encumbrances, liens, and interests in which the estate of the owner is subject. In case the land is held in trust or subject to any condition or limitation, it shall state the nature and character of it. It shall be substantially in the following form. Remember, they always say substantially in the following form because it could take on another form. Now, what is really interesting about this is that this echoes what is in the Uniform Commercial Code as well. Do you remember the definition in the Uniform Commercial Code for certificate of title? Let's look at that real quick. Let's see if there's any similarities between this. Okay. And when we go, thought I had it already pulled up. Y'all hold on. I must have backed out of it. Okay. Let me blow this up so you can see it. And right here, we get down to certificate of title. We can see right here a certificate of title means a certificate of title with respect to which a statute provides for the security interest in question to be indicated on the certificate as a condition or result of the security interest obtaining priority of the rights of a lien creditor with respect to the collateral. Well, okay. Well, isn't that what we were just looking at over here, this certificate of title? It shows that the encumbrances upon here and everything. That's what it has to show, the encumbrances, all encumbrances and liens. Isn't that in harmony with the certificate of title statute in the UCC? It's the exact same thing. I hope I'm going to stop right here. I did a lot of research on this, and it really, I just really didn't feel like I should really be dealing with this bullshit, but it's like people, they call me out and they see all these different things, and I'm like, man, I've been doing this for a long. All these guys on the internet, I've been doing this all this shit longer than all of them have. It's like I'm not impressed. They are out there actively trying to create different remedies because number one, they don't understand secured party. That's number one, it's too complex. And number two, it's just trying to sell you something, you know, like the law changes or something, like they're going to find some, holy grail or something like that. It's almost like, I don't know if people are familiar with the, like the revaluation of the currencies, it's like, 5 years 5 years ago, I became, privy to that information. And I was all excited and everything. And then I came to find they kept saying, it's going to revalue tomorrow. It's going to revalue tomorrow. I had heard that so many different times. And then I found out that they had been saying it was going to revalue tomorrow for like 10 years before I came into it. And that's not to say that the revaluation is not going to occur. I don't want to put that down, but it's like you get to the point and somebody comes to me now and says, well, it's going to revalue tomorrow. I'm like, okay, that worked once, but it's not going to work twice. People are looking for something. They're looking for something for nothing and easy too. But this was very easy, for me to do, just to go in, because first of all, for me to even go ahead and do this type of research, that meant that I would have to read 220 in the proper sense that it was stating. That's why none of these guys have done any additional research because they read it on its face and they thought they knew what it was talking about. And that's not what it's talking about. Anyone who's familiar with statutes knows that in statutes, they all cross-reference each other. And additionally, they always provide forms for everything in the statute. That's why they have forms and pleadings book. There's a form for almost every statute in any state. They have a forms and pleadings book. You can go to your law library and you can verify this. All right. American jurisprudence has a very good forms and pleadings book. Okay, so they have, if they say something in their statute like certificate of title, they're going to have a fucking picture of it somewhere. Okay, that's what I mean by that they do everything. They show you everything that they do. They're required to because they have to be within the ambit of their delegated authority and everything has to be structured. Nothing in the public is done without some delegation of authority. So hopefully I have cleared the air on this and, basically elucidated this particular topic. I'm hoping that I've exhausted it. It seems like Rule 201 should have accomplished that for me. But once again, I know these guys are going to try to find some kind of way to construe this. And it's going to be up to you, the listener, to do your due diligence and find out information when it's being conveyed to you, whether or not there's any validity to it. I'm Yusef, High Frequency Radio. Peace to the gods. I'm out.